Hello there. This is An Architect Goes to Law School. Today in civil procedure class, we'll start talking about the discovery phase of lawsuits. As part of the initial petition, or immediately following its filing, parties to the suit begin the discovery process. The discovery phase is meant to produce evidence for use at trial. Documents and deposition testimony may or may not be admissible and may be challenged by other parties. Pursuant to the rules of civil procedure, documents and testimony are provided by their producers to the other parties for their own analysis and potential use. Unlike many media depictions of lawsuits, surprise documents and surprise witnesses are uncommon. Usually, all parties to a suit get a chance to evaluate the evidence before its introduction at a court proceeding. Knowing that the litigation process differs between the state and federal court systems, the basic components of discovery during litigation consist of the following steps and tools. Upon the initiation of a lawsuit, the parties to the suit are required to exchange certain pieces of information. This is controlled in federal courts by Federal Rules of Civil Procedure, Title V, Disclosures and Discovery. Rules 26A1 through 26A3 provide the roadmap and requirements for these disclosures. Before and during litigation, an attorney representing a client will work with the client to assemble certain information commonly called pretrial or initial disclosures, which usually includes, but is not limited to, correct names of the parties to the suit, names, addresses, and telephone numbers of potential parties to the suit, a general recitation of the facts giving rise to the suit, as well as legal theories concerning the parties' claims or defenses, the economic damages sought and any methods employed in their calculation, names, addresses, and telephone numbers of persons having knowledge of relevant facts, information about the documents relevant to the suit, the whereabouts and contents of which are known at the time of the providing of the initial disclosures, and names, addresses, and telephone numbers of people who may be designated as responsible third parties. In addition to this information, litigants are expected to start producing documents they reasonably know are relevant to the litigation. Rule 26A1A2 states that a party must, without awaiting a discovery request, provide to the other parties, quote, a copy or a description by category and location of all documents, electronically stored information, the tangible things that the disclosing party has in its possession, custody, or control, and may use to support its claims or defenses, unless the use would be solely for impeachment, end quote. It is the client's responsibility to assemble and provide to the attorney potentially relevant documents. While litigation is not always anticipated, it is a best practice to maintain good records, keeping communications that show decision-making process and results of those decisions. This will streamline the process of providing documents to your attorney. It's also a best practice as a litigation client to give your attorney as much time as possible to sort through the information to be produced to remove non-relevant and privileged documents. During the discovery phase, parties may serve each other with various methods of eliciting information. The first such method we'll discuss is interrogatories. Interrogatories are simply questions asked of the receiving party, but they can be statements expecting responses. They are meant to elicit information about the events, facts, and evidence of the litigation. They can be open-ended or yes-no, requiring long or short answers. Examples of this are, describe in detail the process by which you decided to use the exterior cladding product X in the design of the project. Or, did you consider alternatives to exterior cladding product X in the design of the project? Interrogatories are usually limited in number depending on the discovery control plan of the litigation that's underway. For example, in Texas, Level 1 lawsuits have a limit of 15 interrogatories. Level 2 has a limit of 25, while Level 3 has, quote, appropriate limits on the amount of discovery, end quote. Because representing attorneys may not know the answers or responses to fact-intensive interrogatories, They will ask their clients to supply responses. It's a best practice to provide these answers as soon as possible so that the attorneys can meet the response deadline. Feel free to comment, ask questions, and suggest topics you'd like me to discuss. Next up, we'll continue talking about other discovery phase tools. Thank you for watching An Architect Goes to Law School.